Good day, Crime Talk aficionados. We have a great show for you. First, did something big just happen in the Bryan Kohberger case? Not all of Rex Heuermann's family is supporting him. Lori Vallow gets a drag order to come to court. An update on the Karen Read trial, day 30. A Department of Justice employee is accused of spiking his girlfriend's drink to induce an abortion. Big problem. The girlfriend didn't know. We have this day in legal history, our quote of the day, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. And yes, go check us out as well on any of your favorite podcasting apps. Now, before we get started, a couple of things. One, let me remind you to go to crimetalksearch.com. Sign up for that background subscription service today. I'm telling you, information is power. If there's somebody that's coming into your life, maybe a boyfriend, a girlfriend, maybe it's somebody coming into your children's life. You don't know anything about them. You want to check them out. Go to crimetalksearch.com. You can sign up for that background subscription service today. And when you do, you'll be able to get a search literally performed while you wait. The report will be emailed to you, and you're going to get all types of information about this particular individual that you're looking for. And here's the beautiful thing. If it's one person or you want to do 100 searches, you can all do it in your subscription. You're going to get information in that report regarding their phone numbers, their emails, their social media presence, whether they're divorced, whether they're married, whether they have liens and judgments against them. And yes, you're going to find out, most importantly, do they have a criminal history? Going to search literally thousands of public databases that would take you weeks, if not months, to do independently on your own. So go to crimetalksearch.com, sign up today. You're going to be happy that you did. Now, a couple of announcements. We're going to go live tonight. That's right, 6 p.m. Mountain Time. Gee, I wonder what we can talk about. Maybe the Bryan Kohberger case, maybe the Karen Read case. And another bonus. After we go through today's stories, that's right, the BattleBox has arrived. We didn't do it last month because, frankly, the excitement was too great. I couldn't wait when it arrived. I took it home, I opened it, and, well, let's just say I dispersed it to other people in the family, so to speak. Anyway, we got the BattleBox. It's big today, so it's going to be exciting. Big. All right, next on the docket, the court today issued in the Bryan Kohberger case an order staying the stay in that case. Now, what does that mean? So a stay in a legal proceeding, particularly in the context of an appeal, perhaps, is a court order that temporarily suspends or halts the enforcement or effect of pending further action until the appeal is potentially resolved. So in Idaho, stays during appeals are governed by the Idaho Appellate Rules, specifically Rule 13, which outlines the authority of courts to issue a stay in various types of cases. Now, a stay may be sought to prevent the enforcement of a lower court's judgment or order, but here's the problem. We just don't know. It can also suspend the proceedings in the lower court while the appeal is pending. So, like I said, did something big just happen? Normally, when there's a stay in the criminal matter, that could mean normally a couple things. There's been an adverse ruling against the prosecution, and they want to take it up on appeal. Because normally, the defense doesn't get to take up an interlocutory appeal in a criminal case. You have to basically go through the proceedings and then do that. But there are extraordinary measures where you can do that and say, Judge, this affects our whole case. We're going to take it up on what we call an interlocutory appeal, or here we call it a Rule 21, to say, Judge, this lower court judge made a mistake. Asking the appellate courts to say this judge made a mistake. So here, in the context of our question here, we have the sealed order, staying order. Of course, everything's sealed in this case, it's better than it used to be, certainly better than the Lori Vallow and Chad Daybell case, but the reality of it is it's still all sealed. Like I said, normally it halts some action or enforcement, and the order is sealed under specific provisions of Idaho law here. Anyway, an appeal likely pertains to either the stay itself, the underlying order being stayed, or the related procedural matters. Now, the court is, like I said, sealed pursuant to this Idaho Court Rule 32G, and the rule exempts certain judicial records from public disclosures, including records of judicial proceedings or judicial work product exempted from disclosure by statute, court rule, or case law. This suggests the order involves sensitive judicial proceedings, such as those related to maybe grand jury, juvenile cases. Obviously, those aren't really applicable here, but it could result or be a result of maybe some sort of ruling as it relates to the continuance that the defense has sought, or the alternate suspect evidence, which is kind of what I would be leaning towards. But we're supposed to have a hearing for that next week, but maybe the judge made a decision already. The problem is, because everything's done in secret, we just don't know. And also, under this particular rule, under subsection 6 of that particular rule says the case can be sealed, which involves records where public disclosure could jeopardize ongoing investigations or the judicial process. Now, the sealing indicates that the order contains some sort of sensitive information, obviously related to a criminal matter. But like I said, the first thought is, well, maybe there's something related to the grand jury. Well, I don't think so. We've had that pretty much resolved, and that's not really in play here anymore. Could pertain to actions arising from the proceedings, and an appeal may challenge that stay, or even possibly the sealing, but that would be very unlikely. So, without access to the specific content of the sealed order due to its apparently confidential nature, we have to infer that the potential subject matter of the stay based on the legal context and the cited provisions. And so it's plausible scenarios for what the stay may address, particularly in the context of an appeal. Obviously, a stay of a criminal judgment or sentence, that's not really an issue, right? We haven't got there yet. He certainly hasn't pled guilty. He's set for trial. Not staying a grand jury indictment because, well, we know that ship has already sailed. Obviously, he's been indicted. We've had litigation on it. And then that's not really applicable. So then we have the stay of the lower court's order. The stay could suspend the district court or, some other court order, and it could be related to discovery, evidence, or a motion in a criminal case. But most of those have been resolved. There's been no real suppression issues that were not favorable to the prosecution, because they're usually the ones that would take that up and say, Judge, our case can't proceed if this comes in. So we'll just have to wait and see. And then there's always a procedural ruling, such as sealing the order itself, where a party could seal the decision to seal the unsealed records. That wasn't make sense, I guess. And then obviously some administrative or judicial proceedings, because, that might halt ongoing judicial or administrative actions. Like I said, that's very odd. And like I said, I just don't like the way everything is a big secret in Idaho, ladies and gentlemen. It's frustrating to the public, who has just as much right to know what's going on in these criminal proceedings as, well, frankly, the parties. There's nothing that suggests that the public cannot handle whatever is going to go on. And you think that we're not going to find out about it eventually? It just doesn't make much sense to me. Anyway, so if there is an appeal, the appeal likely challenges the stay itself here of some type, of some underlying court decision that prompted the stay. Now, the appeal process in Idaho is governed by the appellate rules. Like in most jurisdictions, they have their own rules. And if the stay was issued by the magistrate, the appeal would typically go to the district court, which is not an issue here. And so therefore, it would go directly to the Idaho Supreme Court. In this particular case, but more likely it's some sort of interlocutory appeal. So really what it boils down to, what are the issues that are pending before the court? Obviously the motion to continue and the alternate suspect information. So the question is, did maybe an order come out saying there's not enough evidence for this alternate suspect? Or did the court say, I think there is sufficient evidence for this alternate suspect? And needless to say, either way, some party in this particular case is saying, let's go to the Supreme Court in Idaho, of course, and decide the issue. Could it delay the potential trial? Possibly, if the Supreme Court takes it up. Normally, when you have a trial court proceeding, and there's an interlocutory appeal, it's basically, normally what happens is the defense files a motion to suppress something, the court grants it, the prosecution says, we think you're wrong, it goes up on an interlocutory appeal. The defense can do the same thing, but literally, I can tell you, usually the Supreme Court takes about 2% of those type of cases because they say, let the case play out and see where things go. So it kind of makes you think that maybe the prosecution lost something. But something's taking place and it's big, and somebody asked for a stay and it was granted, which means somebody wants to do an appeal. Now, what happens? Bottom line is we're going to have to wait and see. Hopefully we have hearings coming up here in the next week or two in the Kohberger matter where we can have a little more clarity as to what is taking place. It should really, most motions hearings do set the stage for the trial. This one clearly will, as it relates to the pretrial issues related to the alternate suspect. So we will see where things go, ladies and gentlemen. We just don't know. I don't like to speculate, but when somebody's requesting an order sealing the stay of the stay, it makes you wonder something's going up on appeal. Next on the docket, not all of Rex Heuermann's family is behind him. We brought you the story the other day about Rex Heuermann's wife saying, well, he's my hero, and I don't think he did it. But, well, not for all the family members. So for those who are not familiar with it, Victoria Heuermann's admissions, it's his daughter, and the case against Rex Heuermann, well, may have just got a little stronger for the prosecution. So the Gilgo Beach serial killings, a series of murders that haunted Long Island, New York for over a decade, have resurfaced in public discourse with the release of Peacock's docuseries, The Gilgo Beach Killer. How original. Anyway, The House of Secrets as well, I guess. Anyway, it is going to premiere on June 10th, which is today, and the 3-part series delves into the life of Rex Heuermann, the 61-year-old architect accused of murdering 7 women between 1993 and 2011, and features an unprecedented interviews with his family, including his daughter, Victoria Heuermann. Now, in a shocking revelation, Victoria, who initially expressed uncertainty about her father's guilt, concludes just a week before the series release that he is most likely the Gilgo Beach serial killer based upon publicly available evidence. So, let's take a look at it. So Victoria's admission and the ongoing legal proceedings draw on obviously verified details and some unverified details related to this source. So let's do a quick timeline. The Gilgo Beach murders began to unfold back in May of 2010 when then 24-year-old sex worker Shannon Gilbert disappeared after making a frantic 911 call claiming someone was trying to kill her in Oak Beach, Long Island. Now, while searching for Gilbert in December of 2010, police discovered the remains of 4 women: Melissa Bartholomew, Megan Waterman, Amber Costello, and Maureen Brainerd Barnes along Ocean Parkway near Gilgo Beach. These victims, collectively known as the Gilgo Four, were found bound, some wrapped in burlap within a quarter mile of each other. And over the following months, the remains of 7 additional victims were uncovered, including Sandra Castillo, Jessica Taylor, Valerie Mack, and Karen Vegata, Tanya Denise Jackson, and her toddler, Tatiana Marie Dykes, and an unidentified person referred to as Asian Doe. Now, while Gilbert's body was found in December of 2011, police maintained she died by accidental drowning, a claim disputed by her family. Now, the case remained unsolved for over a decade, hampered by investigative challenges, including the actions of the former Suffolk County Police Chief James Burke, who was later imprisoned for unrelated misconduct. Now, a breakthrough came in 2022 when a witness linked a green Chevrolet Avalanche to Amber Costello's disappearance, leading investigators to Rex Heuermann, a Manhattan-based architect from Massapequa Park. Now, Rex Heuermann was arrested back in July of 2023 outside his mid-Manhattan office and initially charged with the murder of Bartholomew, Waterman, Costello, and then subsequently investigators led to additional charges for the murder of Brainerd Barnes, Taylor Castillo, and Miss Mack. Now, Heuermann has pled not guilty to all 7 counts of first-degree murder as well as second-degree murder. Now, prosecutors allege that Heuermann led a double life, presenting himself as a devoted family man while committing heinous crimes in his spare time. Now, DNA matches the mitochondrial DNA from a pizza crust discarded by Heuermann matched hair found on burlap wrapping of one particular victim. Now, the hairs linked to Heuermann's and his wife, Asa, were found on 3 other victims. Now, records place Heuermann in contact with the victims, including taunting calls made to Bartholomew's family from near his office. Now, a witness described this green Chevrolet Avalanche registered to Heuermann, seen during Costello's disappearance. Now, there's also a hard drive in Heuermann's basement that contains apparently a chilling document detailed prep for murders, preferring small women as targets. Police recovered over 200 firearms from his home, and Heuermann's search history included queries about serial killers and the Gilgo Beach investigation. Now, Heuermann allegedly targeted sex workers, luring them while his family was out of town, such as during a 2010 trip when Waterman disappeared. Now, Victoria Heuermann, who is now 28, worked at her father's architectural firm, RH Consultants, before his arrest, is obviously a central figure here in the killing. Now, throughout the docuseries, she is going to grapple with the contrast between the father that she admired and the allegations against him. Initially, Victoria expressed doubt, stating she is on the fence about the guilt, citing his presence during 90% of her childhood, but acknowledging the 10% when he was unaccounted for, such as during family vacations that he skipped. She recalls a trip to the Six Flags in 2010 in Maryland when her mother and brother, Christopher, when Waterman vanished, noting her father stayed behind in Long Island. Victoria describes her father as a driven professional whose demanding job caused stress, occasionally leading him to throw plates in frustration, though she insists he was never violent towards the family. She admired his career, aspired to follow in his footsteps, but the evidence, particularly the timelines of the murders, coinciding with the family absences, shakes her perception. And when confronted with the coincidence of victims' disappearance during these 3 periods, she admits, "I'm not sure." And in a pivotal moment, revealed at this series' conclusion, Victoria informs producers a week before the June 10th premiere that based on the publicly available facts presented to her, she believes her father is most likely the Gilgo Beach killer. Now, this admission is a significant shift from her earlier uncertainty and contrasts sharply with her mother's stance. Now, Asa, Heuermann's estranged wife, remains steadfast in her belief in his innocence, dismissing evidence as circumstantial and insisting she will only accept his guilt if he confesses directly to her. Now, Elstrup, who filed for divorce back in July of 2023 to protect her family assets, describes Heuermann as my hero and likens her first jail visit to a first date. She argues that Heuermann's routine, coming home daily, smoking cigars in the garage, and running errands left no time for the alleged crimes. Elstrup also disputes claims about disturbing pornography found on his computer, suggesting it may not have belonged to him. Now, her attorney has stated that Elstrup is withholding judgment until the trial concludes, emphasizing her disbelief that the man she knew for 27 years could commit such acts. So despite the divorce, Elstrup continues to attend Heuermann's court hearings and maintains contact with him. Now, this docu-series features exclusive footage from inside the Heuermann's family home there in Massapequa Park, where some victims are believed to have been killed. Reports indicate that Victoria, Elstrup, and Christopher received over $1 million for their participation, though Elstrup attorneys clarifies she was paid a licensing fee for archival footage. The series also includes interviews with Heuermann's best friend, who confronted him about the allegations, and explores the emotional toll on the family, who returned to a ransacked home after police raided the mansions. Now, Heuermann, who's currently held without bail at the Riverhead Correctional Facility, is awaiting trial. His legal team is challenging the admissibility of the DNA evidence, arguing the whole genome sequencing lacks scientific acceptance, and seeks to split the case into 5 separate trials due to the differences in crimes and as well as the circumstances for each alleged victim. A Fry hearing is set to determine the DNA admissibility. That is set for June 17th, with no official trial date set as of yet for any of the cases. Now, the case obviously has significant attention, amplified by the docuseries and now Victoria's admissions. So the Gilgo Beach serial killings remains one of the Long Island's most chilling mysteries. Rex Heuermann at the center of a complex and ongoing investigation. Now, Victoria Human's admissions that she believes her father is most likely guilty, as revealed in the House of Secrets, underscores the personal devastation wrought in this particular case. And while her mother, Asa, clings to denial, the weight of evidence, DNA, cell phone records, and planning documents, well, they could paint somewhat of a damaging picture as the legal process unfolds, and the docuseries offers a poignant, if unsettling, glimpse into a family torn apart by allegations of a monstrous double life while honoring the memory of the victims whose lives were tragically cut short. We'll give Rex Heuermann the presumption of innocence. Who knows? Maybe his wife and daughter did it. I mean, after all, their DNA was on the victims as well, or through the hair samples, I guess. We'll have to wait and see. I don't know. I think they should get separate trials. I'm not a big fan of lumping individual cases all together just for legal expediency. We'll have to wait and see what the judge does. Next, Lori Vallow's third murder conspiracy trial is still underway, and the judge ordered a drag order. So on Monday, June 9th, the third murder conspiracy trial for Lori Vallow resumed in Maricopa County, Arizona, with the court's minutes and new filings indicate her reluctance to appear. That's right, Lori Vallow didn't want to come to court. Anyway, the court order filed on June 10th revealed that Judge Justin Brensky authorized the Maricopa County Sheriff's Office to employ, quote, any means necessary, including force, end quote, to ensure Ms. Vallow's attendance at the trial. Now, this directive underscores the challenging faced by the court in managing this obviously high-profile case, who, well, she likes to do things her way, and she's kind of used to getting things done her way, except in a court of law. Anyway, Ms. Vallow is already serving multiple life sentences without parole for her convictions in the murder of the two youngest children that she has, 7-year-old Joshua J.J. Vallow and 16-year-old Tylee Ryan, as well as the murder of Tammy Daybell, the first wife of her fifth husband, Chad Daybell. Now, she was also found guilty in April of this year for conspiring to murder her fourth husband, Charles Vallow, in a separate trial, where she represented herself as well. And the current trial focuses on the allegations that Vallow conspired with her now late brother, Alex Cox, to attempt to murder Brandon Boudreaux, the ex-husband of her niece, in October of 2019. Boudreaux fortunately survived the shooting, which occurred outside of his home in Gilbert, Arizona. Now, the court order for forced attendance follows a pattern of disruption in the trial proceedings. And like I said, as noted, Daybell's health-related absence, including an appearance in a wheelchair back on June 2nd, citing that she was nauseous and she had chills, which delayed the jury selection. Despite the health evaluations ordered by the judge, finding no medical reason to excuse her absence, Vallow continued to express reluctance to participate as evidenced by her behavior in court. And then on June 6th, she was removed from the courtroom after she had a heated exchange with the judge, further highlighting the contentious nature of her trial between not only herself and the judge. Anyway, Vallow, like I said, represents herself, maintains that the incidents tied to her charges are not crimes, but tragic family events. In her opening statement, she described herself as a loving and peaceful person, a claim that prompted prosecutors to argue that her character evidence has been basically opened the door to introduce her prior murder convictions. The prosecution asserts that evidence including the use of Vallow Daybell's Jeep in the drive-by shooting and Alex Cox DNA proves her conspiracy with Mr. Cox, Alex Cox, her dead brother, to kill Mr. Boudreaux. Now, you have to obviously kind of despise Lori Vallow, but yet admire her in kind of a weird way. Sure, she's going at this process all wrong, representing herself in court, but she's not doing that bad. She's answering questions. She's allowing doors to be open. In fact, she's kicking doors open to bad evidence because she really doesn't understand the process. Hey, that's okay. Everybody's got to learn on her feet, and she's going to have all that experience to give advice to the other prisoners for their appeals when ultimately winds up in her permanent place in prison. And hey, after all, why not get a little sassy with the judge, right? What are you going to do, judge? Send me to prison for the rest of my life, right? That's probably her attitude and her mentality. So we'll see. Obviously, this trial progresses, And the sentencing for the Charles Vallow conspiracy is pending the outcome of this particular case. For judicial economy, let's just do 2 sentencings at once. And the court's firm stance ensuring her attendance is obviously reflects his commitment, the judge's commitment, to concluding the final chapter for Lori Vallow, particularly in her Arizona trials. Now, we did bring you the story yesterday about her appeal, some 67 pages long. And there's some compelling arguments. And I hate to say it because those are the arguments that I said when the trial was ongoing, that they would be evident, they would be good arguments on appeal. So, like I said, your argument's only as good as the appellate judge that it's in front of. So we'll have to wait and see. Now, don't get me wrong. I think Lori Vallow is guilty of obviously the crimes that she was found guilty of. So she's got 4 dead bodies on her right now, probably a 5th, and who knows, maybe there's a couple more, who knows? She's kind of a black widow. But, you got to give her a fair trial too. And the reality of it is she's got some good issues on the speedy trial, as well as the 404B evidence, which I said all along shouldn't be coming in. There's really shouldn't be any relationship. These are not similar in the sense that it's propensity evidence. They have to be particular as to how they detail it in their 404B notice. They didn't do it. I think they screwed up. Who knows? Lori Vallow, she may get a free pass. She really may in this particular one. And free pass, she may get a new trial. She may get a new trial in her Idaho case. We'll see how that goes. Next on the docket, Karen Reed trial. That's right, day 30th. So let's hit a couple of highlights from yesterday, June 9th, Monday, and today, June 10th. Now, obviously, the Karen Reed trial is centered on the 2020 death of Boston police officer John O'Keefe, and it continued with significant witness testimony on Monday and as well as today, Tuesday. Now, they're at lunch right now. That's why we're doing this particular show at this time. So obviously, check in tomorrow so we can fill you in, or tune in tonight on our live program. Anyway, obviously, the defense alleges that Miss Reed was framed in a police conspiracy, while the prosecution claims that Miss Reed struck O'Keefe with her SUV and left him to die in the snow in Canton, Massachusetts, outside of a house party when a blizzard was coming in. So tensions were high. So Monday's proceedings were marked by some heated exchanges, particularly during the testimony of accident reconstruction expert Dr. Daniel Wolf. Now, the defense called for a mistrial after Special Prosecutor Hank Brennan questioned Wolf about holes in the back of O'Keefe's sweatshirt, suggesting they were caused by road rash. However, it was later revealed that these holes were cut by a prosecution criminalist during the examination. When they were doing their, apparently was noted in some lab paperwork. Brennan said, hey, you know what? I acknowledge I screwed up. My brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. The judge denied the motion for mistrial and addressed the issue by offering a jury instruction to clarify that the misunderstanding of the evidence and allowed the documents about the holes to be entered into evidence. This was the second mistrial request by the defense in less than a week, both of which the judge denied. Now, the day concluded with testimony of Dr. Elizabeth Laposada. She's the former chief medical examiner in Rhode Island with 12 years of experience and involvement in numerous court cases. Now, her testimony set the stage for further examination for today. Now, Laposada resumed her testimony, as I said, delivered critical insights into O'Keefe's injuries and challenged the prosecution's narrative. A couple of the key points that she made is that the medical findings of the head injuries and the cause of death. So she testified that O'Keefe died from brain injuries and skull fractures caused by blunt force trauma to the head. She described a patterned injury on the back of O'Keefe's head, indicating contact with an object, featuring a fine granular pattern and a rigid pattern. She emphasized that this injury was life-threatening, rendering O'Keefe unconscious and unable to make purposeful movements, leading to brain swelling and death within 15 to 20 minutes. Laposada firmly stated that O'Keefe's injuries were not consistent with being struck by Miss Reed's SUV, and when questioned about the speed of a potential vehicle impact, she responded, "It didn't hit him, So it doesn't matter. She reiterated that several times. She said, by looking at the body, I could tell you there was no evidence of impact with the vehicle. She also ruled out injuries to O'Keefe's eyelids as being caused by the SUV's spoilers. Now, La Posada also testified that the wounds on O'Keefe's right arm, shown in court photographs, were consistent with animal bites or claw marks inflicted while he was alive. However, the judge sustained multiple objections by the prosecution, limiting La Posada's ability to specify dog bites and restricting her descriptions to the injuries as consistent with animal bites. She noted that no bone defects in O'Keefe's right arm or hand, stating the bones were 100% intact. And La Posada disputed the prosecution's claim that O'Keefe suffered from hypothermia, citing the absence of stomach ulcerations typical of cold exposure. She compared autopsy photos of O'Keefe's stomach to those of hypothermia victims, concluding he did not die of hypothermia. Additionally, she attributed rib fractures and stomach lining hemorrhaging to the Lucas CPR device used during the resuscitation efforts, not the incident itself. La Posada then testified that the scene outside 34 Fairview Road, based on photographs, showed a flat grass surface with no objects that could have caused the pattern head injury. She suggested police should investigate objects with rigid or granular patterns to identify the cause. Now, on cross-examination, Mr. Brennan's cross-examination with La Posada was contentious with frequent disagreements. And Brennan questioned La Posada's credentials, suggesting she lacked the expertise of a neurosurgeon in brain injuries. La Posada countered that her forensic pathology experience allowed her to determine the timing and impact of O'Keefe's brain swelling. Brennan then challenged La Posada's timeline of O'Keefe's death, the nature of his head wounds, and whether frozen ground could cause a skull fracture. La Posada maintained that the ground could cause such injuries, but noted the scene photos showed no impediments like rocks or bumps, and Brennan attributed the Now, Brennan attempted then to undermine La Posada's credibility by referencing a 25-year-old audit from her time as the Rhode Island chief medical examiner, alleging negligence related to a backlog of reports and her absence from the station nightclub fire scene. Alan Jackson, the defense attorney, countered that La Posada did not leave 1,500 bodies unattended, and that the audit was politically motivated dispute. The judge allowed limited questioning on the backlog of the nightclub fire, but permitted Jackson to rehabilitate La Posada's credibility. So the defense filed another motion to allow La Posada to testify about dog bites, arguing that the prosecution opened the door through prior questioning of Dr. Marie Russell, through Dr. Russell. Jackson called the prosecution's tactics burden shifting and unfair, stating that Dr. La Posada's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog. Period. Full stop, he said. The judge denied the motion, restricting La Posada to describing the injuries as consistent with animal bites and limiting visuals. Jackson called the ruling outrageous, but waived a proposed jury instruction on burden shifting. The judge expressed concern about gruesome photographs, particularly the one of O'Keefe's brainstem. She allowed its use if blood cells were cropped to reduce jurors' distress. X-rays of O'Keefe's arm and hand were admitted, though La Posada's testimony, despite prosecution's objections, as she confirmed reviewing them. There were lots of sidebar interruptions today, as like most days in this particular case, and the disrupted La Posada's testimony, particularly regarding arm injuries and vehicle impact questions. Apparently, the jurors are showing signs that they are frustrated and are bored during the exchanges, though some jurors were attentive during discussions of the hypothermia and CPR injuries and the pattern head injury. Now, the defense indicated that their final witness, Dr. Andrew Rentschler, a biochemist from ARCA, will testify after La Posada, and his testimony is expected to address additional forensic and scientific aspects of this case. And we'll see where it goes, ladies and gentlemen. Make sure we're bringing it gavel-to-gavel coverage. Even though it's on the East Coast, 2 hours ahead, Frank is getting up and making sure we get everything live streamed for you. I wake up in the morning, I turn on CrimeTalk to check it out. It's going to get interesting. And then, of course, we're going to have the case in rebuttal. Today's Tuesday, Wednesday, Thursday, maybe closings by Friday, maybe Monday. I don't know. Nothing has gone quickly in this particular case, so I'm going to guess Monday. Next on the docket, a Texas man, a DOJ employee, is charged with capital murder in an abortion drug case. So on June 6th of this year, Justin Anthony Banta, an IT employee with the U.S. Department of Justice Bureau of Prisons, was arrested in Parker County, Texas, facing charges of capital murder and tampering with evidence. The charges stem from allegations that Banta secretly administered an abortion-inducing drug to his pregnant girlfriend, resulting in the loss of her unborn child, according to the Parker County Sheriff's Office. Now, back in September of 2024, Banta's then-girlfriend, whose identity has not been disclosed, informed him that she was pregnant with his child. Police state that Banta suggested that she terminate the pregnancy and offered to purchase some Plan C, an abortion-inducing drug. The woman, however, expressed her desire to continue the pregnancy, according to the press release from the sheriff's office. Then on October 17th, 2024, when the victim was approximately 6 weeks pregnant, she attended a medical appointment where a sonogram confirmed the fetus and a strong heartbeat. The fetus was in good health. Later that day, she met Banta at a coffee shop in Tarrant County. Investigators allege that Banta slipped the abortion drug into her drink without her knowledge or consent. Security cameras footage reportedly show the victim consuming the entire beverage. The following day, October 18th, the victim experienced severe symptoms, including extreme fatigue and heavy bleeding, prompting her to seek emergency medical attention. She suffered a miscarriage on October 19th, which she and authorities attributed to the drug allegedly administered by Mr. Banta. During the investigation, detectives interviewed Banta and seized his cell phone and potential evidence. And obviously, they claimed that this IT expert remotely accessed the device and performed a factory reset, deleting data that may have been included evidence of the purchase of the abortion drug. This action led to additional charges of tampering with evidence. I mean, hey, if you're going to go down, you might as well go down big, right? Anyway, following months-long investigation, the Parker County Sheriff's Office obtained a felony arrest warrant for Banta on the tampering charge. And while the Texas Rangers filed a capital murder charge in Tarrant County, needless to say, Mr. Banta has been taken into custody and booked into the Parker County Jail. He was released the same day after posting a $500,000 bond for the capital murder charge and a $20,000 bond on the tampering with evidence charge. If convicted, he could face the death penalty. The sheriff praised the cooperation of the coffee shop's owner and staff, noting their assistance was instrumental in advancing the investigation. The case also involves support from the FBI, the Benbrook Police, and the Tarrant County Criminal District Attorney's Office Digital Forensic and Technical Service Division. Texas has some of the nation's most restrictive abortion laws, prohibiting abortion except in cases of dire medical necessity, and a 2021 state law bans abortion after a fetal heartbeat is detected, with exceptions for medical emergencies. Now, while a 2022 law imposed civil and criminal penalties for performing abortions, these laws provide the legal framework for the capital murder charge in this particular case, as the fetus death is treated as a homicide under Texas law. Now, Banta's attorney issued a statement emphasizing that the allegations remain unproven and that Mr. Banta looks forward to clearing his good name in court. And the statement urged the public to respect Banta's privacy and his due process rights. DOJ hasn't said whether Banta is currently employed or has been terminated, but I guess that's the least of his concerns. Anyway, the investigation remains active with both the capital murder and the tampering charges awaiting prosecution, and the police have not released additional details about the evidence collected or the specific abortion drug allegedly used, citing the ongoing nature of the case. Obviously, significant attention. Obviously, Texas has some stringent abortion laws, and the involvement of the federal employees certainly piques people's attention as it relates to this particular case. Next on the docket, this day in legal history, June 10th, 1692. That's right, going old school, ladies and gentlemen. Bridget Bishop becomes the first person executed in the Salem witch trials. She was hanged, notably there in Salem Village, Massachusetts. June 10th, 1752, Congress sets up the first committee with Jefferson, Adams, Franklin, Livingston, Sherman to draft the Declaration of Independence, marking a key legal milestone, ladies and gentlemen, in the nation's history. Declaration of Independence and Constitution. Everybody should have a pocket version handy. You never know when you may need to know your Declaration of Independence and Constitution. June 10th, 1854, the United States Naval Academy holds its first graduation ceremony, a milestone in federal legal establishments of naval officer training. That's right. You have Annapolis, obviously the Navy, West Point, the Air Force Academy, you got the Coast Guard Academy, you got the Merchant Marine Academy, all fine schools, ladies and gentlemen, fine schools. Probably one of the best educations you can get. I never had the privilege to go to such a fine institution, although when I was on active duty, I met many people that were graduates of the Naval Academy. And yes, my son, if I haven't told you once or twice, was a graduate of the United States Air Force Academy, currently flying F-16s. How cool is that? Next, 1873, June 10th, 1873, the Justice Department was investigating bank frauds linked to the Panic of 1873, resulting in the convictions and reforms in financial laws. 1873. Keep telling you, ladies and gentlemen, it's all the same stuff. We just recycle it every 50 years. Anyway, June 10th, 1957, the United States Supreme Court rules in Reed v. Covett that citizens cannot be tried by military tribunals overseas. June 10th, 1968, the United States Supreme Court decides Terry v. Ohio, establishing standards for stop and frisk searches under the Fourth Amendment, right? You've probably heard of Terry stops, ladies and gentlemen. That's right. The Supreme Court addressed the constitutionality of police stop and frisk practices under the Fourth Amendment, and the case arose when a Cleveland police officer, observing suspicious behavior, detained and frisked John Terry, discovering a concealed weapon. The court, in an 8-1 decision, upheld the officer's actions, ruling that police may stop and briefly detain individuals based upon reasonable suspicion of criminal activity and may conduct a limited frisk for weapons if they reasonably believe the person is armed or dangerous. Obviously, this decision established the legal framework for stop and frisk procedures, balancing public safety and individual rights. And next, our legal quote of the day. The jury system allows every case the dignity of its own hearing, a judgment on its own merits without a one-size-fits-all limitation. Now, this quote underscores the jury system's role in delivering individualized justice, emphasizing its importance in ensuring a fair and independent evaluation of each case. And the beautiful thing is, ladies and gentlemen, you got people from the public, 12 people from the public that have to go back to the public and say this was our decision based upon the legal and competent evidence in the trial. But the fact that you get a bunch of citizens to do that is remarkable. Greatest invention ever. Sometimes juries get it wrong. Sometimes they get it. Most of the time they get it right. I will never criticize a jury's decision because they're the ones that made the decision based upon the evidence they had. And maybe the prosecution didn't prove the case. Maybe the defense raised enough reasonable doubt. You just never know. But remember, that decision has to be unanimous. Think about how difficult it is to get 12 people to agree on anything. Go ask 12 colleagues what you would like to do for lunch today. You're going to get 14 different answers, ladies and gentlemen. So the fact that either a case is proven or not proven, it has to be unanimous. Greatest system in the world. And finally, our dumb criminal of the day. The Misadventures of a Man in the Land of Oz. That's right. A tale of misspent cash and misuse of the 911 system. In the annals of ill-advised nightlife escapades, few stories shine as brightly or burn as dimly as that of Sultan al-Nafari, a 21-year-old Saudi Arabian man whose recent foray into the Clearwater, Florida's Oz Gentlemen's Club ended not with a bang, but with a 911 call and a misdemeanor charge. Buckle up, viewers, for a tale of youthful exuberance, misplaced expectations, and a costly lesson in the fine print of strip club etiquette. It was just past the witching hour on Sunday morning when Al-Nafay, fresh off celebrating his 21st birthday, found himself in a pickle at the Oz Gentlemen's Club. Now, according to the Florida police report, our protagonist had shelled out a crisp $300 for the privilege of a private room, expecting, as he later told authorities, well, he expected sex from a club employee. Alas, the employee declined to provide said services, leaving Alfare not only unsatisfied, but apparently indignant enough to call 911 for some redress. One can only imagine the dispatcher's bemusement as Alfawari, allegedly slurring his words and reeking of liquor, recounted his tale of woe. The police report paints a vivid picture of him claiming the club security took his $300, though club staff countered that he willingly paid for entrance into the private room before making his ill-fated request. When his overtures were rebuffed, Alfawari, perhaps unaware of Chris Rock's sage wisdom that there ain't no sex in the champagne room, decided the emergency service line was the appropriate avenue for grievances. Deputy Chase Fales, tasked with handling this peculiar call, arrived to find Alfawari still on the phone, passionately pleading his case. Now let's pause to appreciate the audacity. In a word where most would sink away, chastened by rejection and a lighter wallet? No. He doubled down, treating a strip club snub as a matter of law enforcement involvements. It's the kind of bold, if misguided coincidence that might inspire a chuckle or a cringe, depending on one's perspective. One wonders if Alfawari is his inebriated haze imagined a SWAT team storming the land of Oz to recover the $300 and deliver a stern lecture on customer service. The law, however, was unimpressed. And guess what? Our character was promptly arrested for misuse of the 911 system, a misdemeanor that landed him in the county jail. His freedom was secured only after a $500 cash bail was posted by a Miami flight school instructor. A detail that raises more questions than it answers. Was the instructor a friend, a mentor, or simply a good Samaritan with a soft spot for wayward clubgoers? Court and jail records offered no clues about Alfawari's occupation or student status, leaving us to speculate about his life and the young man who just a week past his 21st birthday ventured into the magical land of Oz and emerged with a rap sheet. The moral of this story, if one must be extracted, is as old as nightlife itself. Know the rules before you play the game. Strip clubs, as any seasoned patron could tell you, are not brothels, and $300, while a pricey sum, does not rewrite the social contract. And, well, our dumb criminal misadventure serves as a cautionary tale for those who might confuse a private room with a personal fantasy fulfillment zone. And let's not overlook the secondary lesson. 911 is for emergencies, not for settling scores with a dancer who didn't deliver the unwarranted expectations. As Alfawari nurses what surely is a bruised ego and a lighter bank account, one hopes he takes his episode in stride. After all, at 21, there's plenty of time to learn the ropes of nightlife and perhaps to invest in a copy of Chris Rock's comedy, Discovery. For now, the land of Oz remains a glittering mirage with dreams are sold but not always delivered, and where a young man's $300 brought him not ecstasy but a night in the county jail and a story for all ages. Mr. Alfawari, you are a dumb criminal of the day. Congratulations, you made it. Now, for those of you that made it this far, guess what? We have a bonus tonight. BattleBox has arrived, ladies and gentlemen. Now, this is not a paid thing. This gets sent to me every month, and you never know what's going to be in it, but you know it's going to be good. And guess what? Fortunately, I have my K-bar here that I got after completing boot camp in the summer of 1988. I haven't lost mine, and it's been to the field. It's been on many adventures. Still have the original sheath. Just goes to show you, they teach you in the military accountability of your gear. Never lose your gear. Always sleep with your rifle. Never lose your rifle. But that's for another story. But needless to say, it works. I think we got all the tape off. Now we need to see what is in the battle box, ladies and gentlemen. Like I said, this is not a paid endorsement. It's just something I get every month. And, it's kind of fun because you never know. Anyway, let's take a look here. Wow, this is big. What is this? It's some sort of carrying thing. Eco-friendly, compact design, dishwasher safe, convenient, sturdy, collapsible, easy storage. Okay. Didn't expect that, but I guess, when the world goes to hell, you're going to need something to carry the water and firewood at, right? And of course, we get the book, tells you what's in here. Let's just see. Apparently, there's a top that comes with that, but that is the Flexware sink, a workhorse in the wild, a 16-liter collapsible sink. is built for hauling water, washing gear, prepping food, cleaning dishes, and everything else. All right, let's take a look. What else do we have here? Cowboy coffee. Honey Badger's Bee Farm Cowboy Coffee. This ain't your average cup of joe, it says. It's raw honey infused with dark roast coffee beans, giving you natural sugar and caffeine in one wild spoonful. No brewing is needed. Eat it straight, stir it into hot water, or smear it on trail food. I don't do coffee, so we'll just put this in the Flexware sink for right now. What is this? This is Ruck and River. Let's see what this is, ladies and gentlemen. Let's see here. Ruck and River. Let's see here. Ruck and River. Oh, is this the, let's take a look here, ladies and gentlemen. This is a vacuum sealer machine. Food storage done right, sealed wild game, dry goods, and leftovers with this compact vacuum sealer to extend freshness and boost shelf life. Ideal for preppers, homesteaders, or anyone wanting to reduce waste and store better. There you go. Ruck and River. Now that can't be it. That's not it. This is the sealer. So you can tell I just opened this. I have no idea. This is the sealer. So we got that going for us as well. So this, I think we're going to need a knife to open this, but I think sharp edges to it, right? Just the way it is. And I think I got a sharpener. I could actually sharpen this K-bar over here. Let's take a look at this. What is this? This is Ruck and River. It looks like it's a knife set. Take a look at this. Because you can't just have apparently one knife. You need a whole bunch of them. Look at that. Look at that. All sharp indeed. Let's see what it says in the book. Ruck and River Kusa knife set rolled by Dead Fish. Field cooking ain't about looking fancy. It's about having the right tool. And this 5-piece knife set brings you the edge you need. Each blade is made from something stainless steel and locked into a waterproof waxed canvas rolled built to travel. Whether you're breaking down a large game, filleting fish, or prepping a full backyard dinner, this set has got you for slicing and dicing. Look at that. We got all kinds of knives in that. Oh, interesting. Interesting. I'm sure the lovely Miss Kristen's going to love that. More sharp object. Let's see what this is. It's a 30-day Duro LED canteen. All right. According to the book, let's see what we got here too. Darkness, not today. Crank this lantern up to 1,000 lumens for full camp visibility, or let it ride for 30 days on low. Impact resistant, weatherproof, easy to operate with a glow-in-the-dark powder button. Glow-in-the-dark power button. That's cool. And let's see here. We got some country-style chicken pot pie premium food. Can't go wrong with that either, right? You never know when you need a meal. And finally, it looks like a portable spoon and knife and fork set, because you never know when you don't need these. So there you go, ladies and gentlemen. Bonus BattleBox edition. That's all we have for today. Remember to join us 6 p.m. Mountain Time tonight for our live program, and then our Patreon show immediately following that. Thanks for watching. We'll see you later. And remember, the Constitution matters.